Question: can you say F off to the police? This is a question commonly asked, but the answer is commonly answered wrongly, partly due to sensational incorrect newspaper headlines over a decade ago, which still influences people's opinions today. Let me make 8 points. Point 1. Generally, it is not an offence per se to swear in public, as per the case of D versus Harvey. Point 2. Having made this point, this post does not seek to encourage you directly or indirectly to swear at anyone, police officer or any member of the public. And however annoyed you may get in a police encounter by an aggressive police officer, does not generally justify repeatedly swearing at them. Point 3. The short answer to the question is it can be an offence in England and Wales for you to say F off to the police under Section 5 of the Public Order Act 1986, but it is largely dependent on the context in which the words FUCK was used by you. Point 4. To explain further, the test to commit a Section 5 public order offence involves 2 elements to be satisfied and proven with evidence. The first element of the test is you must A. use threatening or abusive words or behaviour or disorderly behaviour, or B. display any writing, sign or other visible representation which is threatening or abusive. And the second element of the test that needs to be proved is the words, that is FUCK, or behaviour or writing, sign of other visible representation must be within the hearing or sight of a person likely to be caused harassment, alarm or distress. Point 5. Section 5 of the Public Order Act 1986 is a very broad and low threshold offence. This means it is quite easy to commit a Section 5 offence if you are using abusive words like FUCK at anyone in public for 3 main reasons. Firstly, you don't need to have an intention to cause harassment, alarm or distress. Secondly, there does not need to be any person who was actually caused harassment, alarm or distress. And thirdly, all that is needed to commit the offence is that what you said, that is using threatening and abusive words, that is swearing in public, took place within the hearing or sight of a person likely to be caused harassment, alarm or distress. And this includes not just civilians but also police officers. Point 6. Whether words are threatening or abusive depends on a number of factors and points to consider. A. Not all words are threatening or abusive. They may in fact be rude, distasteful, mockery or insulting. B. Sometimes the use of the F word is not directed at a person or a police officer, but the frustrating circumstances they find themselves in, e.g. this is an effed up situation, or to emphasise a word, e.g. I've effing told you, or a replacement word for nothing, e.g. you won't find F all. I could go on. But the F word can also be directed at a person in an aggressive and angry manner, telling someone to leave them alone, e.g. saying F off. C. There are some words and phrases which, when attached to the F word, have a racial, religious, sexist or homophobic slur, which is more likely than not to be threatening and abusive, that is, having an emotional impact and potency on the person who is hearing those words. And again, this depends on the context. And D, and this one is a key point, any F words used should be understood in the context and circumstances they were said. So for example, a court may conclude using the F word may be abusive during a church service, but less so when shouted during the course of a football match towards an opposing player. Point 7. Where threatening and abusive F words are used, evidence will still always be required that an individual was likely to have been caused harassment, alarm or distress, and this cannot be inferred from the situation. Where witnesses have given oral evidence of an incident which forms the basis of a charge under Section 5 of the Public Order Act 1986, but have said nothing, and been asked nothing about experiencing harassment, alarm, or distress, there is no sound basis for the court to reach that conclusion for itself, as per case law. In other words, evidence is key to a successful conviction, often given in witness statements by a police officer or a civilian, and sometimes also evidenced in an audio captured footage on a mobile phone or on a police body-worn camera. Without the evidence, there cannot be a conviction for a Section 5 Public Order Act, as per the case of Harvey. One final point, point 8, which is often misunderstood, is to suggest police officers cannot be the victims of Section 5 offence if the F word is used in their presence at them because of the nature of their work means they cannot be harassed, alarmed, or distressed. This is not a correct understanding of the law or case law on Section 5. In the case of Southard versus DPP, the word FUCK, the court held whether the person addressed is a police officer or a member of the public, the words FUCKU or FUCK off are potentially abusive. In the case of DPP versus Orum, the court said, I find nothing in the context of the Act of 1986 to persuade me that a police officer may not be a person who is caused harassment, alarm, or distress by the various kinds of words or conduct to which Section 5.1 applies. I would therefore answer the question in the affirmative that a police officer can be a person likely to be caused harassment and so on. And yes, the court also went on to say the nature of their police work means they are less likely to be caused harassment, alarm, or distress. Very frequently, words and behaviour with which police officers will be warily familiar will have little emotional impact on them, save for boredom. It may well be that in appropriate circumstances, justices will decide as a question of fact that the words and behaviour were not likely in all the circumstances to cause harassment, alarm, or distress to either police officers. That is a question of fact for the justices to be decided in all the circumstances, the time, the place, the nature of the words used, who the police officers are, and so on. What this also seems to suggest is that different police officers might have a different level of emotional impact to being sworn at, e.g. a more seasoned police officer compared with a newly qualified police recruit. So can you say F off to the police? Well, if you did, you run the risk of being arrested for a Section 5 Public Order Act offence and leaving the court to decide your fate. The maximum penalty for a simple Section 5 Public Order Act offence is a £1,000 fine plus court costs. Feel free to comment, follow, like and share.